Let me start with this proposition. Governments behave unjustly. They do it often, they do it regularly, and they do it because they can. It's important for everyone to take on government when they behave in that way. And it's particularly important for lawyers because lawyers have some tools to force government's hand. Canada is a constitutional democracy. Under our laws, the Constitution, including the Canadian Charter of Rights and Freedoms, is supreme law. Governments can ignore protests, it can ignore voters, especially in non-election years, but it doesn't get to ignore the law. It can't ignore the Charter. So if you can convince a judge that government has violated the supreme law, you single-handedly can hold the government to account. That's what it means to live in a society governed by the rule of law. Chief Justice Fraser of Alberta, in a dissent, I say in a dissent because it's on leave to the Supreme Court of Canada at the moment, and I'm asking for the leave, so hopefully it'll turn into a majority judgment someday if we get very lucky, said, "The greatest achievement through the centuries in the evolution of democratic governance has been constitutionalism and the rule of law. The rule of law is not ruled by laws where citizens are bound to comply with the laws, but government is not. Or where one level of government chooses not to enforce laws binding another. Under the rule of law, citizens have the right to come to the courts to enforce the laws against the executive branch. And courts have the right to review actions by the executive branch to determine whether they are in compliance with the law and, where warranted, to declare government action unlawful. The right in the hands of the people is not a threat to democratic governance, but its very assertion. Accordingly, the executive branch of government is not its own exclusive arbiter on whether it or its delegatee is acting within the limits of the law. The detrimental consequences of the executive branch of government defining for itself and by itself the scope of its lawful power have been revealed often bloodily in the tumult of history. When government does not comply with this law, this is not merely non-compliance with a particular law. It is an affront to the rule of law itself. I don't want to minimize, by focusing on government, on the tremendous immunity that our structure gives to foreign and multinational corporate interests when they act improperly. Usually they are protected by governments or, as in the case of our federal government, bought by governments, bought by the oil sands and the oil manufacturers. But they are largely immune, except for shareholder suits, a technique which has not been sufficiently developed to actually control corporate behavior at all in this country, and which take decades to litigate and are very, very costly and hard to succeed. Hence, corporations, unlike government, have a de facto immunity, which they ought not to have. So I'm going to pick 3 cases to talk about, focusing on challenging governments. First, some you win. In 2007, we took a constitutional challenge against the government of Ontario on the privacy of adoption records. The government was bringing in a new part of that law, which was provided that even deeply personal information could be disclosed without the consent and even contrary to the wishes of someone who had been adopted or the birth parent who had adopted them. birth parent who had given them birth. Importantly, this new law was to have retroactive effect. So people who were adopted decades ago or given up their child decades ago and had all these years expected that their records would remain private would suddenly have their records opened up without their permission. The example is the Catholic matron, now age 40, who when she was 18 had a child out of wedlock and gave it up for adoption. All of a sudden, that child had the right to come back and pick at her church, so that her entire community knew about her youthful indiscretion, regardless of whether she wanted that information public or not. I represented 3 adoptees and 1 birth parent who tried to challenge it, and we said that this violated the right to privacy, which the Constitution and the Charter guarantee. We didn't quarrel with those who said, look, we want to reveal this information. Nothing wrong with that being done on a voluntary basis, even for past behavior. Nothing wrong with changing the terms of adoption as a whole. If society decided that from now on we were going to have less stigma attached to the fact of being adopted or giving a child up born out of wedlock, that made some sense. And it may well be that that turns out to be the better way to go. That's the law in Ontario at the moment. No quarrel with any of that. The only quarrel was with those who had been promised privacy and suddenly were to have it stripped from them because government had changed its mind. The court agreed, ultimately. Justice Bella Baba of the Superior Court in Toronto said that this constituted an invasion of the dignity and self-worth of each of the individual applicants, and the right to privacy as an essential aspect of the right to liberty in a free and democratic society has been violated. It defined an interest protected by Section 7 of the Charter, which he put as the right of citizens to make fundamental life choices without interference from the state. The decision whether to learn about or meet or have the world know about one's children or parent is a deeply personal choice. It should be an individual, not a government, who makes that decision. When we won this case, we were very worried about an appeal. We were very worried about it because we had no money for an appeal. And as it turned out, though the case had attracted almost no attention despite my best efforts during the time up to the hearing, as soon as the hearing was over and we had won, literally every newspaper in Ontario of any size did an editorial saying that was the right decision. Justice Bella Baba was right. And just about then an election intervened. There was the same government, but a new cabinet, new seats at the cabinet table. And so what we did, and this is part of how you make your way through not just litigation. We wrote a letter to each member of the new cabinet in Ontario, enclosing copies of all 30-odd newspaper editorials that were uniformly in favor of the decision, and begged them not to appeal further. And it worked, of course. The government thought that making Sandra Pupatello, the minister who had pushed this, happy was somewhat less important than starting off with a fresh slate with a new cabinet. No one wanted to take on the last cabinet's dirty laundry. But that was a good example of how to protect successfully a decision, because the courts might well have overturned that, but they never got a chance to do it. A second case is Michelle Douglas versus Canada. This is a little while ago. It's 1992. And I call this one, sometimes you win really big. It's atypical, in fact, in how it happens. We'd like to think that all of humankind is on the path towards greater decency, greater compassion, and greater understanding of each other, especially our differences. But sometimes the majority is slow, and sometimes government is even slower. And that's when lawyers can step up and give a push in the right direction. The Michelle Douglas case is an example of that. Michelle was born to be a soldier. She joined the Canadian Armed Forces, the daughter of a federal deputy minister from a good middle-class family in Ottawa, in 1986 as a direct entry officer. She performed really well in the armed forces. The following March, she graduated at the very top of her class and was promoted to second lieutenant. Her award for doing so well in the military was to get posted to a plum posting, the military police. Over the next 2 years, she did her job, she did it well, she had brilliant reports, she was well on the way to becoming a middle-level officer. In the summer of 1988, she was repeatedly brought in for interrogation by fellow military investigators. Her offense? She was suspected of being a lesbian. At that time, no one who was gay or in practice suspected of being gay could serve in Canada's military. I remember doing cross-examinations because the first place we went was to the Security Intelligence Review Committee to challenge this designation, which was a security withdrawal. That's what you got when you were gay. And I remember some colonel sitting across the desk and saying to me, under oath, "Mr. Ruby, you just don't understand. You don't know what it's like to be under fire in a pup tent with people inside your tent who are gay." And I tried to get him to explain exactly what the problem was. And he couldn't, and I couldn't understand it. But there was a very strong feeling in the armed forces at certain levels that this was wrong and that the policy had to be maintained. Ultimately, they treated her very badly. Her boss one morning came to get her. They flew her to Toronto to the military air base. There was a motel near the air base, and they questioned her for 3.5 days, giving her no access to counsel, food and water, but that's about it. And they questioned her over and over, and they grilled her to get her to admit that she was a lesbian. She finally did, and they dismissed her. We challenged that by taking it to the Security Intelligence Review Committee. And ultimately, in this secret room in Ottawa with, double rooms, room inside a room, with the highest possible security, the CERC officer reviewed the case and said, "This is entirely unjustified. She's been treated in a way which makes me ashamed to be involved with the government of Canada," and ordered that she be reinstated in full. We breathed a sigh of relief. We've won. And then the Supreme Court of Canada came down with a decision in another case within days, saying that the deputy ministers of each department were not bound by CERC rulings. And they ignored the CERC ruling. And they upheld the dismissal. Oh my God, what were we going to do? We'd spent years getting this far. So we thought about it, and the we is myself and Sven Robinson, who was then an MP, and decided to start all again at stage one. Let's start with a single action for damages and breach of the Constitution against the Government of Canada, and we'll start in federal court, and we'll just work our way through. Well, federal court is a very slow place. It's not a court that moves with any kind of speed. So years went by, and finally in 1992, we got to the courtroom door. I had been called 3 or 4 days before that by the government lawyers, who explained to me that, "Gee, Clay, the trial starts, we've got 15 days set aside for it, but we really want to settle this case. We think it's right to settle." This is the lawyer saying this. "And we're trying to persuade our clients to settle." I said, "But we don't want to settle this case. We want a ruling that this is unconstitutional and that it'll never happen again, and we want a huge whack of money for Michelle Douglas." Yes, she said, that's what we want too. So we gave them a few days. We didn't prepare. And the next thing you know, it turns out that the chief of staff thinks it's a wonderful idea, that he doesn't want this rule either. He has this clear notion that soldiers should be judged on their ability to perform rather than their sexual orientation. And it then had to go to Brian Mulroney to get him to sign off on it. And it turned out, according to what the lawyers told us afterwards, that Brian Mulroney had a gay brother. Who knew? And he was very sympathetic to this problem, and he approved it. So we traipsed into a federal court judge in the ordinary way you do in hundreds of cases, and present him a series of papers and say to him, sign here. And it's quite amazing, because he signs. And then it's over. Then you have an order from the court which says this is unconstitutional, a declaration that it must stop. You have a check of huge amount being sent to Michelle, and you win really big. So sometimes, and that's the high water mark of easy result, it's just fabulous to bring these actions against government. Particularly so in this context because the Army and the armed forces are hierarchical. So when the order comes from the top, everybody obeys. And indeed, in the armed services, we've had relatively few, if any, problems about integrating gays and lesbians into full service. It's now a place where it just happens. And the Americans have called us to find out, how did you do it? Because they're interested in doing it there and are having such difficulty. The third category is, of course, sometimes you lose. And these are heartbreaking occasions. Courts are by nature conservative. No politician ever appointed somebody a judge because they were a brilliant troublemaker. Indeed, merit has, in my experience, absolutely nothing to do with being appointed a judge. And so courts tend to be conservative. They tend to be composed of people who have proven their loyalty to the status quo. They may be progressive, they may not, but essentially they understand the status quo and do not want it to change. And so you all remember the pit bull hysteria back in 2005, which led then Attorney General Michael Bryant to ban pit bulls in the name of public safety. The issue is a simple one. Is the problem dangerous dogs by appearance, or is the problem dangerous owners who are simply untrained and ungoverned? There are some people who really want a large dangerous dog. And the government's way of dealing with those people was to ban the dog, the pit bull breed. Under that legislation, legal ownership of pit bulls was limited to those who were then owned by a resident of Ontario at that time, and any pit bull born within 90 days of that time. And any other pit bull were completely banned. That is, they could be killed, and were killed. So it was a stupid law then, and it's a stupid law today, and it cried out for a charter challenge based on the proposition that inherent in this vague legislation, I'll get to the vagueness in a moment, was the irrational notion that you can judge or measure the dangerousness of a dog by its appearance, because dogs were banned based on how they appeared. We put forward expert evidence to show that there is no science behind the notion that the danger posed by an individual dog is caused by its breed affiliation or its appearance. And the government's experts, with the exception of one dog catcher from Ohio, agreed with us. Second, to the extent that you can generalize about particular breeds, pit bulls were not close to being the most dangerous breed. One of our experts indicated that over 83% of American pit bull terriers and American Staffordshire Terriers, both of which fell within the statutory definition of pit bull, passed the temperament test administered by the American Temperament Test Society. And that was a higher pass rate than was given to Border Collies, King Charles Spaniels, or English Sheepdogs. Another of our experts, the president of the Ontario Veterinary Medical Association, who was there speaking for the association as a whole, which regarded this legislation as being absolutely irrational, pointed to a study in 1996 that found that pit bull terriers accounted for only 4% of reported dog bites in Toronto. And third, on the vagueness issue, we argue that the term pit bull didn't define a real category. The legislation defined it as including a pit bull terrier, a Staffordshire bull terrier, an American Staffordshire Terrier, an American Bull Terrier, the latter being a breed that is not recognized in Canada by the Canadian Kennel Society, or a dog that has an appearance and physical characteristics that are substantially similar to these dogs. Think about it for a second. An appearance and physical characteristics that are substantially similar to these dogs. Well, most dog owners don't know their dog's lineage. And most dogs are a mix of 2 or more breeds. Even when breeds are purebred, there are, according to our CMVA expert, there were at least 24 pure breeds of dogs that have substantially similar appearance and physical characteristics to the breeds specified in the legislation. And that was just the purebreds. When you got into mutts and mongrels and multi-racial dogs, the number was practically infinite. So we argued it was vague, that you could in fact find the class. And we lost. Judge Herman, the applications judge, considered the evidence we put forward and then reviewed some conflicting evidence that the government put forward. The conflicting evidence was a professor from the States who mostly agreed with us, and one Ohio dog catcher. The Ohio dog catcher subsequently was fired, and Ohio had, having passed this legislation, ultimately repealed it after these events on the grounds that it just simply didn't work. But rather than resolving the conflict by making findings of fact, which is what judges do on a daily basis in case after case, she resolved the conflict by appealing to the dreaded principle that you will run up against again and again in fighting government: deference. The legislation, in her view, was not overbroad because, in the face of this conflicting evidence, the legislature was entitled to decide that there was a sufficient body of evidence with respect to the inability to identify dangerous pit bulls in advance of an attack so as to justify restrictions that apply to all pit bulls. All pit bulls defined that broadly. Now, those of you who've watched the Insight case with interest may be saying, hey, what about Insight? Because in Insight, the Supreme Court of Canada did weigh the evidence. They didn't refuse, saying, hey, government's got a policy, they have some scientific basis for the harm analysis they think will ensue if people are allowed to use drugs in the supervised context. The other government has a different view, but the government of Canada gets to choose. So there may be some opening now to demand that courts do more of what courts are supposed to do and less deferring. But Insight was a struggle between 2 governments. This is a struggle between an individual and a government, and that may make a huge difference. So, Judge Herman did agree with me that the references to pit bulls and pit bull terriers were unconstitutionally vague because they weren't breeds and not subject, therefore, to breed standards. He didn't know who they were. But the Court of Appeal overturned that conclusion and restored the legislation in its entirety. So we sought leave to appeal to the Supreme Court of Canada, and we didn't get it. You have to get used to the idea that you're going to lose. Losing is not an excuse for stopping the fight. In a sense, your success will be marked more by the number of times you've lost in a good cause than by the number of times you've won. Because if you never lose, you're not taking on enough fights, or you're not taking on the right fights. I continue fighting. I consider it a duty of every lawyer to take on injustice wherever they find it. The profession that you are about to enter is not well suited to making buckets of money. There are other far easier ways of getting rich, even though a few lawyers in fact do get rich practicing law. The practice of law is a call to public service. Northrop Frye has a lovely quote. The society a person has to live in is identical with the one he wants to live in for some people. So all that person has to do is adjust to that society, to see how it works and find opportunities for getting ahead in it. Nothing wrong with that. It's what we all do. But it's not all of what we do. The world we live in and the world we want to live in become different worlds. One is around us, the other is a vision inside our minds, born and fostered by the imagination, yet real enough for us to try to make the world we see conform to its shape. The second world is the world we want to live in. But the world want is now appealing to something impersonal and unselfish in us. Nobody, Professor Frye says, can enter a profession unless he makes at least a gesture recognizing the ideal existence of a world beyond his own interests. A world of health for the doctor, of justice for the lawyer, of peace for the social worker, a redeemed world for the clergyman. So I say to you with Prince Kropotkin, who is an anarchist most of you have never heard of, ask your teachers what you need to know to make this the kind of world you want to live in. Demand that your teachers teach you that. If this is not to some degree your goal, give it up. Give up your place at this law school. Give it to someone who will do more than make a living and make the world safe for corporate capitalism, safe for the rich, safe for business interests. You can do better than that. And you must. Thank you.